You're watching Education for Health Professional Regulators of Ontario, colleges under the Regulated Health Professions Act. Richard Steinica is a senior partner of Steinica Mikura LeBlanc, and he practices exclusively in the area of professional regulation. Richard is a noted author of the Complete Guide to the Regulated Health Professions Act, which, because of its comprehensive nature, has been cited by courts and tribunals, even in cases dealing with non-health professions. Marshall Molesky is the past president of the Federation of Health Regulatory Colleges of Ontario, and he serves as Chief Executive Officer and Registrar of the Ontario College of Pharmacists. Join Marshall and Richard now as Marshall poses a number of important questions on behalf of those of us who want to know more about regulating healthcare practitioners in Ontario.
Richard, colleges operate as part of our legal system. Can you give us an introduction to our legal system for us non-lawyers?
Sure. There's, in essence, two kinds of law. There's enacted law and case law. Enacted law are things like statutes that are enacted by the Legislative Assembly, regulations, and bylaws, and they're hierarchical. A statute takes priority over a regulation. And then there's decisions made by courts, that's called case law or common law, that are equally law as well as an enactment. There's a third category that's sometimes used, soft law, for example, when the college enacts a standard of practice, but it's a little bit different, and I'll talk about that in a moment.
What are some of the statutes that apply to colleges?
There's a lot. You start off with the overriding statutes, like the Canadian Charter of Rights and Freedoms or the Ontario Human Rights Code, and if any provision in your statute is inconsistent with one of those two, then your statute doesn't apply. Then there's statutes that directly apply to you. So this would be the Regulated Health Professions Act, and each college has its own profession-specific act as well. In addition, there are a number of other statutes that are related that apply to some aspects of what you do. So for example, the Statutory Powers Procedure Act applies to the committees that hold hearings, the Discipline Committee and the Fitness to Practice Committee. The Personal Health Information Protection Act deals with patient information and allows, for example, a practitioner to share information with the college without consent of the patient. Then you have the Drug and Pharmacies Regulation Act that not only deals with things that your college addresses in terms of inspecting pharmacies and their rules, but it also defines what a drug is, which is important because prescribing or dispensing a drug is a controlled act.
Perhaps you can explain how to find your way around the Regulated Health Professions Act.
You really wish it could be simpler, but it isn't. There's the main part of the Regulated Health Professions Act that deals with matters external to the college, like the minister and the advisory council and the appeal board. Then Schedule 2 of that, an appendix to that act, is the Health Professions Procedural Code, which we call the Code, which is really what you're going to be dealing with most of the time, and it deals with the operations of all of the colleges. And then there are, for each profession, a profession-specific act that deals with matters specific to each individual college, for example, the composition of the council of each college. So to give some examples, the minister's powers and duties are dealt with in the main part of the RHPA. The controlled acts that only certain practitioners are authorized to do are dealt with in the main part of the RHPA. However, the objects or mandate of the college that I was talking about earlier, that's in the code, as well as the 7 committees that the college has to have, and their mandate, that's dealt with in the code. Now, the scope of practice of each individual profession is dealt with in the Profession-Specific Act, as is the title that's protected to members of that profession.
Richard, who makes what sorts of regulations under the RHPA?
There's 2 types of regulations under the RHPA. The first is made by the minister directly, and that deals with things that are common to all of the professions. And for example, it would deal with health professional corporations or exemptions to the controlled acts. Then each college makes regulations about matters that are specific to that profession. And there are 3 core regulations. One deals with registration requirements, another deals with what is professional misconduct, and the third deals with the components of the quality assurance program. In addition, colleges can make a whole bunch of other regulations on other topics such as record keeping, access to public meetings, inspections, whatever.
I know. What sorts of matters are dealt with in the college bylaws?
Bylaws focus primarily on what's internal to the operation of that college. They might, for example, set out how the professional members are elected to council. They would indicate what officers your college might have and how they are selected. In addition, they would describe or outline how the members of each committee are appointed or selected. And they would also deal with things that have some public interest component. For example, the additional items in the public register would be set out in a bylaw, as would the fees that are paid by practitioners and applicants for registration and other people.
How does case law supplement enacted law?
Case law has 2 main roles. The first is to interpret statutes, regulations, and bylaws to clarify any ambiguity they might have. And secondly, courts set out procedural fairness rules that are expected whenever an entity like the college is dealing with someone's rights. And so they might be called procedural fairness, it might be called natural justice, the Americans call it due process, but that's the second mandate or function of courts. So there are some examples of cases that are quite significant. For example, F.H. McDougall says that the burden of proof on the college in discipline hearing is the civil standard of proof, balance of probabilities, not the criminal standard of proof beyond a reasonable doubt. Katzman, in the Ontario College of Pharmacists, says that when you deal with a complaint, you have to stay within the 4 corners of the complaint. You can't expand the complaint to deal with other issues. Cezanne and College of Physicians and Surgeons of Ontario gives a lot of guidance as to what powers the investigators have and the duty of cooperation of practitioners when there is an investigation.
What is the difference between soft law and hard law?
Well, soft law is an informal college enactment. It's not a formal enactment like a regulation or bylaw. It's informal. And it deals with things like standards of practice for practitioners, record keeping, or it might also deal with how to maintain professional boundaries. And those are not directly enforceable in discipline. You can't say, well, you didn't do what paragraph 3 of the standard practice said, but it can be used, for example, in the complaints process or the quality assurance process to identify the expectations on practitioners. Another form of soft law is when the college issues policy statements as to what it will be doing. So, for example, it might give guidance to the registration committee and to the public as to how the registration committee assesses whether an applicant is of good character or not.
Thank you, Richard.